the advantage to a person having an attorney present for a field interview?
Well, as we were discussing earlier, these interviews are made to elicit certain statements from you. They're there. It's almost like, in some instances, like a deposition. You're obviously not there making objections or making a record, but what you're telling them can be used against you. And it's important that you have a lawyer there representing your interest, understanding what that process is going to be about, and also there for the consistency of what they're going to say your statements are later on, and what they're going to put into their claim file and in their record. It's going to be important because they may put something in there that's completely different from what you said or you thought you said, and your attorney's there taking notes. They're there advising you. If you need to take a break and you need to talk to your lawyer, they're there to do that.
Right. Two other things. I always find, number one, that the preparation of the claimant for the field interview is essential, and in order to do that, especially from our perspective, we have to have the complete claim file, not the claim file, but all the correspondence sent back and forth between the carrier and the claimant. We have to have a copy of all the medical records of the claimant so we can see if the doctors are documenting restrictions and limitations that are consistent with what the claimant is saying he or she can't do. We have to see the financial records to see if the financials are consistent with what the claimant's telling the disability company, the amount of money that they were earning. So I find the preparation is extremely important for those field interviews. And I also find that whenever I'm at field interviews, I'm always interjecting comments to clarify something that I think could immediately be a red flag, or something that the field interview person is honing in on to try to shape the claim towards a certain area that myself especially, knowing the definition of disability in the policy, knowing certain limitations or things that could jeopardize benefits, I'm going to tell that claim person right there, and make sure, or field person, make sure that they have that written down so that it's clear to the company that this is our position and not what you're trying to make it be.
Exactly, and I experienced it today. But before going touching in on one of the things you said within preparing for the field interview, having an idea of the financials, all the medical records, and that goes back in the cases and the claims that we're able to assist on the application. We've had that because the field interview a lot of times comes before benefits have been approved. There's been a decision. So even the good thing about having an attorney early on is that they've reviewed everything, and you can start to see where there might be red flags. And like you said, in it, the field interviewer, today I had it, they started going into policy language, trying to define what material and substantial meant with it, and they're trying to elicit information from the client as to what he thinks.
And the claimants have no idea.
They have no idea what what it means. It's realistically, it's legalese for the most part. So it's a matter of really making sure you don't get pigeonholed.
Right. Oftentimes, they haven't seen their policy since the day they purchased it. And then they're being asked, well, what do you think this means, or what's this mean to you? And it's just another way for the carrier to use a statement that you make against you, and you could say, oh, well, yeah, I think that maybe you're right, maybe I am partially disabled when I read this definition, but in reality, maybe you're not. Maybe in reality you're totally disabled because you can't do those essential duties that are your bread and butter.